same job, same hours, and less pay, that's illegal. And it's happening in almost every industry. Human resources for a company is not there to help you. They're there to protect the company.
As a successful lawyer, Amir Nayebdadash has been fighting legal cases for years, representing hundreds of women and minorities who were paid unfairly and winning them sizable settlements. We asked him 15 questions about equal pay law in California.
You have a man and a woman, and they're performing the same job and the same duties and have the same responsibilities, that they should be afforded the same and equal pay. It's simple. Really what it comes down to, in the gender context, are you a woman that's doing the same job as a man and getting paid less? If that's the case, then under California law, there's enough there for us to take a look at and investigate. And if you will look at historically pay rates for men and women, you will see women have gotten paid less performing the exact same job, having the same exact qualifications, working the same amount of time as their male counterparts. Part of where the Equal Pay Act comes from is because women were being penalized for having babies, taking leaves of absence, things of that nature, being more family oriented than, let's say, men. And what was happening is that they were performing the same duties as men, but because they were taking some leaves, some family time, things of that nature, employers were using that against them to pay men more. That's where the Equal Pay Act really comes in and seeks to cure that wrong because of those things. If you have a situation where someone has been working with the company longer, for example, has more qualifications, has more experience, yes, that person, regardless of their gender, could theoretically be paid more. However, if you have two people, one male, one female, that essentially have the same qualifications, but the male is getting paid more for doing the exact same job as the woman, that's illegal. It's not a hard test to meet. It's essentially saying you're doing the same job. For example, the type of equal pay cases that we handle, people come to us and say, hey, I'm a salesperson and I have counterparts that are male salespersons, but I'm getting paid less than my male counterparts. So essentially, if they're performing the same job, sometimes companies will classify employees differently or give them different job titles, but they're performing the same job. And so it really comes down to the job. If the job at the heart of the duties and responsibilities are almost the same, then you're performing the same job and you should be getting equal pay doing those duties and responsibilities. No, they can't. And that's why the law is written the way that it is. The law does not say for the same exact job. What it says is substantially similar, because employers have found that by simply titling some person a manager and titling another person assistant manager, they're performing substantially similar duties, that they can justify paying males more than females, for example. The employer's only recourse under an equal pay type situation is to say, this person has worked with us longer, this person has slightly better education, this person has slightly better experience. But at the end of the day, the law recognizes, while those things are a consideration, at the heart of what that man and that woman in that same job are doing is the same. And if they're doing the same thing or substantially similar work, they should be paid equally. Even though it's illegal for employers to prohibit employees from talking about their pay, most people don't. Most people find that to be private and they don't discuss it, but they should be discussing it, because they should know, one, that they should be paid the same as their, for example, male counterparts, and two, if they're not, they should be contacting us and making sure that they are. Yes and no. When there's a little bit more discretion, you will see unequal pay happen more. But if you're starting out a position like an entry-level job at like a retail chain or a fast food chain, a lot of times there won't be equal pay issues at that point. As you progress in your careers, that's where the disparity becomes more obvious, where they are using things like family, time off, things of that nature against particularly females to justify paying men more for the same exact job. Recently, we've had some of the larger tech companies settle some large cases. They found at the executive level or even at the higher management levels, they were paying men more than women. But absolutely, you do see that you'll have a group of managers that are Caucasian getting paid more than a group of managers that aren't Caucasian. So it definitely happens in those contexts, and that's also why the equal pay laws apply to those protected classes. This is common, and these are the types of cases that we handle. We've had clients contact us and say, hey, I learned that my male counterparts were getting paid more. I raised this with my management, I raised this with the company. In most instances, they either ignore them, and in the instances that we've stepped in, they've gone ahead and terminated them, retaliated against them for making those complaints. That's completely protected activity, and if that's happened to someone, they should contact us. Our client not only made the complaint verbally, but she memorialized it in an email. She wrote an email to HR indicating that, hey, I'm performing the exact same duties and responsibilities as my male counterpart, but I'm getting paid X dollars less. That's what really fortifies the case of the evidence. Cases where people don't write things down, don't give written notice to the employer are more difficult. They're not impossible, but they're more difficult to prove than cases where they actually take the time to write the email, and that email protects them. And that's the reason why we were able to get compensation for our client for the wrongful termination that she suffered. Women sometimes take maternity leaves. That's where it starts. I think it's a pregnancy discrimination issue that is the catalyst a lot of times for these equal pay cases, because employers recognize we might hire Jane Doe, right? And Jane Doe might enter into a relationship sometime in the future. She might get pregnant, and now she might leave work for 5, 6, 9 months, however long, depending on the type of leave that she needs. And employers don't want to deal with that. And in order and really to punish and prevent that from happening, they will incentivize people not to take those types of leaves and also reward people that don't take those types of leaves. That's one way that you can show a disparity in pay, by having two employees, again, working in substantially similar jobs, by giving one person a higher bonus than the other, even though, like for instance, their performance reviews are equal and their job performance in every other way is equal. I think you should always memorialize in writing by bringing it to human resources. But remember, human resources for a company is not there to help you. They're there to protect the company. So if you don't really think that you're going to get protection from the company, I think you should contact an attorney first. Like our firm can help you craft a response or craft a letter to human resources that says the things in the right way to hopefully effectuate change as a result. And if they don't, then if the company takes action against the employee, at least they're protected. A lot of times employees will go ahead and shoot an email off to the employer, to HR, complaining without saying things in the right way, without identifying the correct issues, and that can be used against an employee. And so if you really believe that your rights have been violated in any way, you should contact an attorney first for some direction. It's the best way not only to protect you, but to effectuate that change that you're looking for. I think the biggest fears that they have are potentially the employer finding out that they're contacting a law firm. Obviously, there's the attorney-client privilege, and no employer will find out. The other reason is that they know lawyers are expensive, and maybe they think they can't afford a lawyer. Both of those are myths. If you contact my law firm, all of your information is confidential. It'll never be shared with the employer unless we have your consent to contact the employer on your behalf. We're also a contingency firm, which means that we pay for all of the fees and costs, and we don't get paid until you get paid. And if we lose the case, then you're not out of pocket. 98 or 99% of cases settle. What we're looking for is economic justice for our clients. We are ready and willing and want to take cases to trial. That's not the issue. What happens is that after working the case up, the employer realizes that they've done something wrong, and they're willing to compensate the employees a fair or reasonable amount. The vast majority of employees and people that are injured will take the settlement rather than risk going to trial, because there's always a risk going to trial. You never know what a jury is going to do. So a settlement which may be less than what you can get at trial sometimes is a more safe bet. If it's the same job, same hours, and less pay, that's illegal. And it's happening in almost every industry. Call Protection Law Group. We protect your equal pay rights.